Greetings, everyone. I hope I am doing this right. This is my first recording. I was talked through it on the phone, so there may be some technical snafus. In this first lecture, I would really like to just simply review what you've already seen and you've already heard. If you go to the Canvas shell, you will see the series of notes that is labeled the Supreme Court Lecture 1 and 2, and it's under the heading, I Observe Old Cushing is Dead. I gave you 5 overviews, you may remember, to start off this section. The first and the most important of those overviews was the fact that the Supreme Court is an incredibly political institution, that presidents nominate Supreme Court justices who they believe is going to see their view of the world. Presidents typically nominate 98, 99, even 100% of their nominees to the court are going to be of their own political party. The least partisan president in the last 100 years was Gerald Ford, and even President Ford nominated 81% of justices of his own party. Senate confirmation, you may remember I told you that when the president and a Senate majority are of the same party, nominations sail through over 90% of the time. When they're of opposing parties, it's only slightly over 60% of the time. So certainly Senate confirmation has a very, very political tint to it. And finally, the third point under that first observation or that first overview was that even the notion of life tenure for Supreme Court justices is political because Supreme Court justices decide whether or not even to retire based on who the president is. So if you are a conservative justice, you want to retire when there's a conservative president because you want someone of your own political party to replace you. If you are more liberal, you want a more liberal president to nominate your successor, because the last thing that you want to do as a Supreme Court justice is to retire and then have the president nominate a justice who is going to undo everything that you have stood for perhaps the last 20, 25, or 30 years. Now, obviously, the first overview leads into the second overview, which is in your notes, and that is that presidents have no idea how much influence they're going to have on the Supreme Court when they become president. Remember, I told you that President Carter, he did not get to nominate a single Supreme Court justice his 4 years as president. On the other hand, President Roosevelt, all 9 of the justices that he nominated to the Supreme Court were by him. So he had total influence over the court. If you look at the last several presidents, the norm seems to be 2. Whether it is Donald Trump, whether it was Barack Obama, whether it was George W. Bush or Bill Clinton, all of them nominated 2 justices to the Supreme Court. The last president to nominate more than that was Ronald Reagan. President Reagan nominated 4 justices during the 8 years that he was president. The third overview, the notion that the Supreme Court is the least dangerous branch. Remember, the founding fathers, they believed that the judiciary would be the weakest branch of government. They lack the power of the purse, which constitutionally was given to Congress. They lack the power of the sword as commander-in-chief that the president usually has. And as Alexander Hamilton pointed out oh so well in the Federalist Papers, not only that, but they lack the power to enforce their decisions. And in Brown versus the Board of Education, we saw that. The Supreme Court in 1954, and if you watch the embedded video at the start of this module, I put a film on that talks about the Supreme Court, and it talks about what a momentous decision Brown versus the Board of Education was in 1954. The problem is that despite the fact that legally this was an incredibly important decision, remember it had limited applicability. And the reason that it had limited applicability was that Southern states refused to implement Brown. And the result of that was that 98% of black school children in the Deep South were still attending all black schools 10 years after Brown. So effectively, Southern states nullified the power of the Supreme Court, and it was not until 1964, when the Civil Rights Act was passed, that you actually saw significant compliance throughout the southern part of this country. The fourth overview that I went over was the one that you may remember troubled me. It disappointed me a little bit because my concern is that it's almost like we're making a statement about ourselves. And that fourth overview was that for a significant period of time, at least 5 decades now, we have had more trust in the Supreme Court than our other institutions, than the Congress, than the president. And this has been a consistent feature in terms of polling data, that Americans trust the Supreme Court more than any other institution. Of course, what troubles me is that as Americans who profess a profound love of democracy and democratic values, we have no influence at all over the Supreme Court. These people are nominated by the president. They are confirmed by the Senate. They are there for life. And so we have no influence over them, and yet we have the most trust in them. The House of Representatives, which we actually have the very most power over, the entire body is up for re-election every 2 years. We trust the Congress the least. And so that kind of concerns me because we have this tremendous trust in a very anti-democratic institution. The fifth and the last of those overviews was, remember when I pointed out that the Supreme Court is a very political institution, that it is political from top to bottom, but it's part of a 3-tiered. I'm talking about the Supreme Court today, but all 108 federal courts are political. Remember, all 108 courts, all of those federal judges are nominated by the president. They're all confirmed by the Senate. They're all subject to life tenure. And you know, I illustrated that I know someone who is a federal judge. One of my former colleagues here at Merced College, his wife is a federal judge, and she went through that same political confirmation process as a Supreme Court justice would. But the creation of these other 107 courts was different than the Supreme Court. The Supreme Court is the only court that is mentioned in Article 3 of the Constitution. If and when I ask who or what created the Supreme Court, your answer is either going to be the Constitution or Article 3 of the Constitution. Those 2 lower courts that I talked about, the U.S. Court of Appeals and the U.S. District Courts, were created by Congress. Congress created all of the lower courts, and the initiation of what I call the federal court system was created by the first significant and major act of Congress. Make sure you underline or put stars next to that, Judiciary Act of 1789. The second concept that I talked about, out of the 3 that we got to before we got separated by this horrible crisis, was this notion of jurisdiction. Remember that jurisdiction is simply the authority to hear and decide certain cases, that there are 2 components to it. The first one is, are we dealing with a federal or a state crime? And so it would go to the appropriate courts. Obviously, if we were dealing with a state crime, the trial court for the federal courts are the U.S. District Courts. The nearest one is in Fresno. If we were dealing with a state crime, then it would go to the local superior court Every county in California has a superior court, so our superior court is in downtown Merced. And if a state crime were committed, the trial would begin in downtown Merced. The other court, and the one that I'm most interested in this court, are courts of appellate jurisdiction. The major court of appellate jurisdiction for the federal court system is the U.S. Court of Appeals. The nearest one is obviously in San Francisco. I talked about that. The ultimate appeals court is the U.S. Supreme Court in Washington, D.C. The state of California also has 6 state court of appeals, and the ultimate state court of appeal would be the state Supreme Court in Sacramento. The difference in what I want you to distinguish is this notion that the trial courts are interested in what we call the facts of the case. They go to a jury. The jury then decides innocence or guilt. Appellate courts are interested in the application of the law, the constitutional claim. Did the trial courts give the defendant a fair trial, or maybe even did they give the state a fair trial? Was there a procedural error? Was there a constitutional provision that perhaps was ignored? And I use the example of Gideon versus Wainwright. Remember, the basic facts of that case were really quite simple. Did Mr. Gideon break into the pool hall, steal the quarters out of the machines, and steal a gallon of wine? A jury determined that yes, indeed, he had committed the crime, and so he was convicted and he was sent to prison. But while he was in prison, there was an appeal lodged, and the appeal was lodged claiming that Florida had deprived him of a basic Sixth Amendment right, which was the right to counsel. Remember that before 1963, states had the option. If states desired, they could provide a public defender like California did, but most southern states, including Florida, did not. In other words, if you could not afford an attorney, then you had to defend yourself in court. Mr. Gideon, who did not even complete elementary school, was forced to defend himself in court against a professional prosecutor, and the result was very predictable. They found him guilty. He was unable to field or have an adequate defense. And when the case was appealed to the U.S. Supreme Court in 1963, the U.S. Supreme Court ruled that Florida had deprived him of a basic Sixth Amendment constitutional guarantee, which was the right to counsel. So the U.S. Supreme Court told Florida, you must give this man a retrial. You must give this man a retrial with a public defender at taxpayer expense. And in that particular case, a public defender was able to expose a very, very weak case of the prosecution, and Mr. Gideon was found not guilty. So in this first lecture, I've tried to summarize, again, material that you've already heard, but given the fact that we had a week off, I thought that you needed to rehear those first 2 concepts, the 5 overviews and jurisdiction. In the next lecture, I'm going to begin the lecture with how presidents choose justices, and I have gone over 3 of the 4, and then I will finish that off, and then I will begin the new page, which will essentially be talking about how cases are decided. So I hope this first lecture came through okay. If you heard it, please send me an email and let me know that the recording sounded okay to you, that you understood it. You should, because now this is the second time you've heard this information. Take care. I will be on again very soon.